Hey guys, let me walk through the arguments that the guardian ad litem, Taylor's attorney, and Dakota's attorney made. I'm gonna have to go quick here. I will not have covered everything, so feel free to add your 2 cents in the comments. The guardian ad litem went first and again was the most important voice on in the hearing besides the commissioner. The court ultimately went with what the guardian ad litem had recommended. And so the guardian started out by saying, we've got these assessments, we've got the recommendations, and if the parties just follow through with the recommendations, it's going to address the underlying problems that this family has. He indicated that the DCFS will continue to be involved for a long time. I think he said for a significant period of time to allow tracking the progress on the issues and the plan, the safety plan that they have and the plan moving forward. He knew the caseworker, and said that the caseworker would continue to do announced and unannounced visits at both homes to make sure that Ever is doing well, and then recommended unsupervised visits with Taylor having minimum parent time. Now, Taylor's attorney decided to take kind of a different approach. Taylor's attorney first talked about the assessments and also said, look, yes, of course, they're really, really credible. At least the one for Taylor is. He talked a lot about all the collateral information Taylor had given the assessors that really lended itself to being a much more credible assessment because the person who evaluated Taylor was different than the person who evaluated Dakota. And then Taylor's attorney spent a lot of time talking about, look, I actually think Dakota's assessment is wrong. Dakota's assessment shouldn't be trusted. It should be redone, they actually ask. They claim that, look, he didn't give sufficient information. He didn't identify that he was the primary aggressor. Or that the police report said that he was the primary aggressor. And so ultimately the court did sort of push back. I think that was an argument that had some good optics maybe, but the traction just never took. In part because the guardian ad litem of course, Dakota's attorney defended that it was a very true report or assessment, but so did the guardian. And the guardian indicated that, look, there was nothing else that was being required. I think we can trust these assessments. And so that was a sort of attempt, but it didn't land. One of the other main themes that Taylor's attorney advanced that I just don't think ended up working out as well for him is he'd said, if you read the assessment, Dakota portrays himself like he walks on water and Taylor is the devil. And the court actually lifted that representation from Mr. Swinward in giving the ruling and rejected it and said, look, I read the assessment and I don't think that that's what happened. I don't think that that's how Dakota sees himself, nor that that's how he sees Taylor, but that both of these people view themselves as victims here. Erica also spent some time talking about the progress that Taylor's done, the therapies that she's engaged in, the buying a new home, the stability that she's been establishing here, that she's been devastated by this. I think that the Taylor's attorney did a good job at sort of appealing to the emotion that, this is not just Ever and Taylor's relationship that's being impeded, but the other 2 children's relationships are also being negatively impacted here. And so we're looking at that sort of narrative was one of the stronger parts, in my estimation, from the argument. He had indicated as well that, look, this is like a race. And he said, the metaphor is like a race. And he said, Taylor is at the start, has gone through, and is kind of on the path. She's on the track. However, he said, Dakota hasn't even started because he wasn't honest in the assessment. He did indicate as well, preemptively, he'd said that there were allegations made by Dakota in his affidavit, twofold, the social media and the missed parent time, that he wanted to address. And he said, with respect to social media, he said either the court should give it 0 weight because both have engaged in sort of concerning social media behavior, but then really talked about, tagging Jesse. He called it witness intimidation, that it would be disparagement. He did say, and I thought this was smart, to say, Taylor's navigating, trying to talk about her journey, and she wants to use discretion, but also wants to document her healing. And I think the court then pushed back a little bit and said, look, there is this provision in the stipulation that says you guys aren't even supposed to talk about each other online, including social media, and that would be memorialized in the order that the court was going to make. With respect to the missed parent time, Taylor's attorney got first bite and said, look, of course Dakota's going to make a mountain out of this, but ultimately it's really understandable why she didn't exercise parent time. The supervisors weren't always available. It's a huge ask, particularly on a holiday like Mother's Day, and the baby was sick. And so she was navigating, hey, look, a really sick kid. And then finally says, and at the end of the day, she was trying to navigate being a mom to a kid who she's watching, based on his representation, the attorney's representation that is, really struggle in this parent time, short time, this really quick exchange and the trauma. And that he said Taylor had to make the decision as a mom, the hard decision to put the needs of Ever first, and that even though she knew it would risk Dakota, like he did, weaponizing that against her in a future hearing, she still made that decision. And the court didn't seem as concerned about the missed parent time. He then also talked about Dakota's home, his work, the lack of stability, lack of financial security. But the court didn't seem terribly concerned about some of those issues. It is interesting that on his financial declaration, I guess, with respect to the DCFS evaluation, Dakota listed himself as a stay-at-home dad. And Taylor's attorney kind of pushed back on that and said, as a stay-at-home dad, how's he making any money? How's he going to be able to pay for these things? And so I thought that was an important kind of prong to be hitting, even though it didn't seem like that had a ton of traction with the court. Then Dakota's attorney went and said, look, there's a lot of speculation about this assessment. The reality is the assessment's good. And the assessment isn't just singular, and because these were written by different people, the absence of some of the process that was in Taylor's, even though it's not in Dakota's, doesn't really mean too much. He also had said, that Dakota has accepted what he's been tagged as a failure to protect, not DV. And then the court chimed in and said, yeah, but I found him having committed domestic violence. He said, right, I said, and this is where I think Dakota's attorney did not do himself any favors, because he said, right, we advanced that it was self-harm, and you said, no, it was more than self-harm. And then the court actually said, yeah, I said it was domestic violence. You never want to be told, you never want to give the court an opportunity to remind you and itself of a finding that was really adverse to your client's interests. I think that was not really well done. Dakota had brought his therapist. Actually know the therapist, she's really great. But that he'd said, look, he's also got PTSD, navigating, doing EMDR therapy, looking at trauma bonding, looking at coercive control. And the therapist was there to really say she could talk to the court, but the court didn't really want to hear from her. The court was like, no. I don't really know exactly why. He did keep saying, look, he's the victim of domestic violence. He was attacked first. And he's going further than what the recommendations from DCFS were. The arguments about him being attacked first, again, the court kind of kept saying, look, that ship has sailed. I found both of them aggressors. I found both of them to have been victims of domestic violence and perpetrators of domestic violence. You're almost relitigating this. That was very much the tone I got from that. He then said, look, and there was this issue called PCIT therapy, parent-child interactive therapy. It is kind of like the gold standard, and it's really like parenting functioning to help people learn how to parent better. He'd said, look, Dakota has been trying to do this for the last couple of weeks with their son, and mom isn't allowing it. And then he said, what mom doesn't want their child to have a healthy relationship with their dad? That mom. And then he said, that's actually an evidence of her mental health struggle. I thought that was I think the first half was smart. I think the second half was not as successful. He then also talked about the house and said, look, Dakota lives in a 6,000 square foot house. Crew lives in the mother-in-law suite. They don't live next door to each other, like in bedroom situation. And he said, you can vet Crew. He had a criminal issue 9 years ago and fireworks 8 years ago. The 9-year-ago issue was dismissed. So again, kind of undercutting that. He did also talk a little bit about the stipulation is really about non-disparagement, and mom has been disparaging like crazy. And he also said, look, there's this issue about missed parent time, and I don't know why she's missing any parent time. She should be not missing any. They went back and forth, then went back to Eric, and then went back to Brent, and then went back to Mr. McDonald. But when the court ultimately came down, I think what the court was really saying was, all right, if supervision was the biggest roadblock to you exercising all of your parent time, I'm going to give you another chance. Let's come back in a month and see how much parent time you exercised and how it's going without that roadblock there. And so I would imagine on July 8th, we're going to have more of these reports, hopefully less mudslinging and a lot more problem solving.